I'm Chandrapala from Armchair Criminal. I welcome you all to this part of the program. This is the fourth part of the four-part series on unavailable witnesses. In this part of the program, I propose to consider the admissibility of hearsay evidence from unavailable witnesses through fear, or where the witness gives evidence but does not cover the point. My first question that I'd like to pose: when does section 116 subsection 2 operate, and how does it differ from other gateways such as death and ill health? When does section 116 subsection 2 that operates? That is to be found in the act in itself. I have highlighted the important concepts of this part of the act in red square brackets, and it reads as follows: that through fear the relevant person does not give or does not continue to give oral evidence in the proceedings, either at all or in connection with the subject matter of the statement, and the court gives leave for the statement to be given in evidence. What it means is that there are three concepts to be borne in mind. First, there must be fear to refuse to give evidence. Two, the witness does not give evidence or does not continue to give evidence on the subject matter, which I just mentioned. Third point is the judge must give leave. When we considered other gateways under section 116 subsection 2, you would have noticed that leave was not a specific requirement in those provisions. Next, I propose to ask the question: what are the main features in applying the concept of fear? The important concepts are to be borne in mind at this stage is the definition of what is fear. Two, the fear must be operative. In other words, it must be the reason not to give evidence. If it is not, then one could argue section 116 subsection 2, it does not apply. Then the consequence of that fear being caused should be the reason to refuse to give evidence or continue to give evidence. Finally, there is a procedure to invoke section 116 subsection 2A procedure. At this juncture, let's consider what is the definition of fear. Again, this is defined in section 116 subsection 2. You would find the definition in subsection 3. Like previously, like always, I have highlighted the relevant concepts in red square brackets. For the purpose of this subsection 2E, fear is to be widely construed, and for example includes fear of the death or injury of another or of financial loss. What you note here is specifically defines that fear is to be widely construed. On this point, I would propose to consider the case of Shabir, which we have looked at earlier. This was the attempted murder, and where the witness gave very crucial evidence. If I recall correctly, it was the identification But there came a point that where he was seen by the mental health doctor who certified that he is able to give cogent evidence, yet he refused to give evidence. And on that occasion, he told the police officers that he has suffered basically violence and abuse in the prison, and that he fears for his family. But in that case, the officers had told the witness, a man called Ravi, I think, that his statement would be read. When he was convicted and appealed, remember the Court of Appeal quashed that conviction, because by virtue of telling the witness that his evidence will be read, that undermines the whole concept of relying on fear. What the court did find is that there was no adequate evidence to establish that there was indeed fear. Secondly, that there are strong reasons to question the reliability of the witness, of his as giving evidence, as the alleged victim was himself. Sorry, forget about that part of the. There was reason to question his reliability. Equally, it is worth looking at the case of Crown and Bolton. The defendant in this case was convicted of rape and other serious assaults, as well as a joint charge with two others on witness intimidation. The witness intimidation was indirect. Once the witness came to court and explained why she was not willing to give evidence, and the judge allowed her statement to be read under section 116 subsection 2. On appeal, it was argued that the real reason she did not want to give evidence is because she didn't want to be challenged in the witness box. In other words, basically unwilling to submit herself to the trauma of giving evidence. In determining that issue, the judge had asked the reasons for not wanting to give evidence, because she was produced before the court on a warrant, and the court accepted that she has received threats. The judge reminded her civic duty to be courageous and give evidence in criminal cases. What she said in return was, I don't want to be made a martyr out of this. When the defendant appealed to the Court of Appeal, the Court of Appeal accepted that the judge's decision to allow the evidence was correct. And from what she has said, that there could be no other conclusion that could be made. And for that reason, the court dismissed the appeal. The next question that I like to ask does it matter if the author of the fear is not the defendant? The answer is in section 116, 2003 Act, where the section 116, 2003 Act, no, Article 6, require that the author of the fear has to be the defendant. Therefore, it matters not who is responsible for causing the fear, so long as the defendant or by someone else on his or her behalf. Then the question arises, if the answer to that question is no, that it doesn't have to be the defendant, where the defendant is indicted to stand trial with a co-defendant. In other words, there's defendant A, who's responsible for causing the fear, and there is defendant B, who is the co-defendant. The strict interpretation of section 116 subsection 2E would allow the Crown to adduce the statement under section 116 2E. See the case of Ravi. But the court will look into the background of the case and its history. In this particular case, it was a case of aggravated burglary, an account of perverting the course of justice. There was evidence of threat and interference on a mobile phone, that of the co-defendants. Whilst two witnesses have lied to the police on certain matters, but what they had found said that the time of the police arrived can be proved and to be reliable, and that the trial judge took the view and applied with great care to allow section 116 2E to operate. There are, in fact, the case of Al-Khawaja, Tahiri, and Rat, Article 63D, were looked at. The defendants were convicted and they appealed to the Court of Appeal. There the Court of Appeal again took the view that the judge was correct to have admitted the absent witness's statement to be read because of fear of giving evidence. In that case of Ravi, what the trial judge did do is basically a textbook style application of the law, because the judge was able to say there was prima facie evidence and its strengths and weaknesses can be considered by the jury and assessed properly. So therefore there was no difficulty in understanding the case and why and how these witnesses didn't give evidence. Next question that I would pose: fear, is it subjective or objective? Answer to that is it's subjective. It has to be. You are looking at a particular witness. You take your victim as you find it. That is the concept basically working through. In this case, look at the authority of Doherty. Doherty was a case where two brothers had attended a football match and one of them got injured. The defendant got charged. One of the brothers, the witness, went back to Ireland where he was practicing as a solicitor, and suddenly he started receiving calls, even to the extent saying that you better meet me on giving a particular date, and that happened to be the date, if I recall correctly, basically the date of the trial. True enough, the witness didn't know who was this person, pretending to be some kind of an estate agent or a property dealer. Couldn't really put his finger and say this is the person and this is why he's ringing me, but gave him enough information to fear for him and for his young family. He refused to come and give evidence. And the court allowed the statement to be read. There the court of, when the case was appealed to the Court of Appeal borrowed a paragraph from the case of Selig, which we have looked at earlier. And I read from paragraph 53. It says, more difficulty arises in cases where it is not quite so clear-cut, but the court believes to a high degree of probability that identified witnesses are being intimidated for and on behalf of the defense, and where the court is sure to the criminal standard of proof that the witness cannot be traced and brought before the court, in our view, having regard to the rights of victim, the families, the safety of public in general, it still cannot be right for there to be some absolute rule that where compelling evidence is the sole or decisive evidence, an admission in evidence of the statement must then automatically lead to a defendant's article right being infringed. That would lead to a situation in which, more successful the intimidation of the witness, the stronger the argument becomes for the statement cannot be read. If the decisive witness can be got at, the case must collapse. Though more subtle, less easily established intimidation provides defendants with the opportunity of excluding the most material evidence against them. Such an absolute rule cannot have been intended by the European Court in Strasbourg. So there you say, if the defendant is allowed to say, my Article 6 is infringed, then more severe the threat, more likely the witness will refuse to come. In that case, his argument for Article 6 even strengthens further. That cannot be right, because if that argument from the defense is correct, then what they are really doing is allowing people to profit from their wrongdoing. That is important to bear in mind. And And in paragraph 28, this is what the Court of Appeal said. The exercise which judge was required to perform was a balancing exercise. Broadly, the risk of unfairness to the defense because the evidence could not be challenged, as against risk of unfairness to the prosecution because it could not be put before the jury all the available evidence. This is not strictly the exercise of a discretion, but something similar to it. It is evaluative and fact sensitive, and the sort of exercise which the trial judge is in the best position to perform. The court will therefore only interfere if it is satisfied that the judge's conclusion is obviously wrong, as it was put in the case of CPS and CE 2006 AWCA Crim 1410 at paragraph 40, perverse or unreasonable. Now you can say that if the judge has exercised the discretion, the Court of Appeal is not going to interfere with that. And correctly so too, because the judge will know, would have had the feel of the case as it was developing. Next, what I propose to ask myself is, when should the fear be operative? The fear should be operative at the time of trial. It is no good being operative some other time. Here, the victim made a statement with regards to an allegation of kidnapping following demand on paying off drug debts. Some months before the trial, the victim made a statement where he had received threats and may not give evidence, stay around to give the evidence, in fact. However, he remained in the area and he himself was arrested for allegations of drugs. No evidence was adduced at trial as he was not located for several months. Therefore, the trial judge, having heard the evidence from the OIC, explaining the witnesses' concern and fears, allowed the evidence. He was convicted and he appealed. The Court of Appeal stressed the need to establish that the fear must be operative at the time of the trial and that out-of-date information is insufficient. And the Court of Appeal accepted this approach and said that there needs to give and take in this. So the prosecution knows how to open the case to the jury. And the case also points out the application under fear has two main parts to the application. One, there should be evidence to support what is fear. Then the court has to apply, is it in the interest of justice to allow the evidence in. So when the judge considered that, he would have considered all that to take the decision. There, in fact, for the purposes of deciding there should be oral evidence being led by the prosecution so that the fear can be assessed in reference to the time at which the witness was expected to give evidence. The next question that I would like to ask is, what is intended effect of the fear? Here, the answer would be, the effect of the fear should be to prevent the witness giving evidence. If there is evidence to that effect, the reason the court would not allow the person who's putting the fear on the witness to deny the witness giving evidence is because that person would be allowed to profit from that. And at the same time, such behavior will only disturb the integrity of the criminal justice system. The next point that I would like to ask, what is the witness fear of doing? You got to look at, for the effect of the fear, the cause. What kind of an effect had it have on the witness? If the witness suffered fear of giving evidence at the trial, or having started to give evidence, to continue to give evidence, in other words, refuse to give evidence any further, then that evidence is incomplete. At that point, the paragraph that deals with this particular point comes into play. Look at section 116, subsection 2. A person does not give or does not continue to give oral evidence in the proceedings, either at all or in connection with the subject matter of the statement. Now, a good example of this is the case of Adejo and Manifukadas. Here it is a very, very important case on the point. The case involved a murder, attempted murder, and possession of firearms. The witness who suffered injuries gave an interview as the defendant. Later, the police came to realize that he, in fact, was a victim himself. Therefore, they took a statement from him. And there, he basically said identically the same thing as what he has said in his interview. The importance of it is that if he had lied, he would have contradicted himself. But here there was no such problem. And in fact, I think he gave 3 statements altogether. The second witness, B, too gave, but he lied to the police. Thereby he undermined the witness A's evidence. Then what happened is that he did not give evidence, he was declared hostile. Judge, having gone through the procedure, including he was asked if he was in fear, which he denied. When his interview I'm referring to witness A here. His interview was played to him during the trial for the purposes of cross-examination. The defense tried to exclude that evidence because the witness would not give evidence on the point. Their argument was, if he does not answer questions that the prosecution is putting, he is not going to answer our questions either. The judge refused that application. And in fact, if I recall correctly, in that trial, he even tried to walk out of giving evidence. The case went on to the second trial. In the first trial, when he was first asked questions, he was asked, are you in fear? He denied it, but didn't answer the questions that was pertinent to the case. When the case went to the trial for the second time, there was ample evidence that he was in fear, and that's the real reason that he did not give evidence in the first trial. Then the witness gave evidence very reluctantly and admitted that he has given witness statements to the police, and he tried to walk out of after answering few questions. The trial judge very carefully went through section 119 and section 116 and allowed the evidence in. The defendant was convicted and he appealed. The Court of Appeal dismissed the appeal. It's very important to understand that because we have counterbalancing factors, the courts will invariably, or almost invariably, will find that the conviction is safe. That is because even if there is an engagement of Article 6.3d, right to a fair trial, the Court of Appeal considers one thing. What they look at is the conviction safe? If the conviction is safe, no issue, because that is all what they are looking at. The next question that I like to pose is, what are the consequences and the situation where the applicant is responsible for the witness's absence, i.e., you are the cause of the problem? I think I have covered this point quite a lot now. The key part of it is the party at fault cannot profit from that fault. If it is the fault of the party who is seeking to adduce the evidence, the hearsay evidence, that is responsible for the unavailability of the witness to be cross-examined, then that party cannot rely on section 116 subsection 2. In other words, you cannot cause the witness not to come to court to give evidence and then say, he is not here for me to cross-examine. Well, the short answer is you are the one who stopped it. That's as simple as that. The answer is very well stated in section 116 subsection 5 of the Act. Again, the important concepts are in red square brackets. It reads as follows: a condition set out in any paragraph of subsection 2 which is in fact satisfied is to be treated as not satisfied if it is shown that circumstances described in that paragraph are caused A, by the person in support of whose case it is sought to give the statement in evidence, or B, by a person acting on his behalf in order to prevent the relevant person giving oral evidence in the proceedings, whether at all or in connection with the subject matter of the statement. Remember, I said that earlier, either the person or somebody who's acting on his behalf. If he did not, if nobody acted on his behalf, then he is clear. He can't be held responsible. But if there's in a causal link, then that person will be held responsible. It may be desirable to look at the case of Ravi. Here, the defendant was convicted of murder. The defendant had sent several messages to the victim, to the witness, which could only be described as threats. The witness did not want to give evidence and left the country and to Spain. His mother, this is the witness's mother, was able to confirm that he was in fear. And the police were able to confirm the same. The Crown initially wanted to adduce the witness's evidence, but following the defense case statement, they abandoned the idea because the defense case statement answers the very point that they had in mind asking the witness. Excuse me. And the defendant wanted to adduce the witness's evidence. In other words, now they want to rely on the hearsay evidence. Under section 116 subsection 2c, of course they are not going to say E, because then they are blowing their own case off the voter. So they said it is under C and D. But the judge refused, as it was held that the defendant himself was responsible for causing the fear in the witness to give evidence. Therefore, in that situation, the judge invoked section 116 subsection 5, which we just considered, and said he is not allowed to rely on that evidence. At trial, the defendant wanted to adduce it, but he was not able to adduce that favorable part. And when he was convicted, he appealed to the Court of Appeal. The Court of Appeal endorsed the learned judge's finding and said that the refusal was correct. This goes to show that one cannot expect to profit from their own wrongdoing. Otherwise, what will happen is it will undermine the whole policy of this legislation. Next question that I'll pose is, would section 116 apply if the absence was not caused by a party to the proceedings, such as not the fault of the defendant or the police, but by a third party? No. because the object of section 116 is to preserve the integrity of the parties, of the proceedings to the party and the criminal justice system. So if they are not responsible, nobody is not going to penalize. Here, let's look at the case of C. In fact, when you look at, if you're to go on the law reports, it will come as BC. The complainant had committed suicide before the trial had commenced. Therefore, it was clear that section 115, subsection 5 did not apply, as the complainant was not regarded to the proceedings there. The facts were this. The defendant was charged with sexual assault on his daughter. Before the trial, the complainant had left a suicide note, which was unfavorable to the defendant. The Crown sought to adduce the ABE and the note. The defendant objected on the basis of section 116, subsection 5, and said that it should be denied. And she is the one who took her own life. Therefore, the Crown should not be allowed to rely on that material. The trial judge was against that submission, and the Court of Appeal held the trial judge was correct, as the deceased complainant was not a party to the proceedings. And the correct interpretation of section 116(5) applies to the defendant at any event to the complainant took the life because of the case. There you say that although the complainant committed suicide, it was as a result of the circumstances that she was put in the first place. Because it is the stress and anxiety, fear, everything that led. In my view, if I understand that case correctly, whilst he's been tried for that offense, it should not be the case that he should be held responsible for that sad death of the complainant. Because the causation, I would argue there's an issue of causation there. Here, where the admission of the hearsay evidence of a person who had died, the evidence was sought under section 116, subsection 2A. In the proviso of section 116(5), that the circumstances, namely the person's death, if it was caused by a person in support of whose case it is sought to give evidence, then that evidence would be inadmissible. Here the person meant the defendant or somebody acting on his behalf, not the deceased. Next question that I pose, where the fear is not the reason. If the fear is not the reason not to give evidence, then I cannot see a difficulty of this because fear has no relevance, in which case it may very well be that if it is the prosecution's application, they may have to rely on some other provision, like section 114, which we will look at separately. If you look at the case of Nelson, this deals with a self-confession concerning 2 murders, double murder. There was independent evidence who had rung the Crime Stoppers and gave details of a murder weapon that was eventually found in a graveyard. But she did not want to identify herself. However, she left a note written with lipstick to say where the murder weapon was, having learned from the defendant's family. And the police traced this informant. Initially, she refused to give evidence, and eventually she gave a statement. When the case came to court, the relationship between the police and this witness had deteriorated so much. She had to be arrested and brought to court. Unbeknown to everyone, that is the day when she had a hospital appointment for cancer treatment. Therefore, one could understand how she would have felt having to miss a hospital appointment for cancer treatment. Then, earlier, having a fallout with the police, she would not have been best pleased to come to court and give evidence. It was argued whether section 116 subsection 2A should apply, and eventually the judge gave the permission to adduce the statement because it was established that she was in fear, but at least the dominant reason for not giving evidence was the fear, albeit at that time the court was unaware of the cancer treatment. Then the matter went to the Court of Appeal, and it became apparent that what the witness has said can be corroborated, can be proved by what the family members of the defendant had said, and nobody has challenged the witness as evidence on the material part, how that came to, how she came to be, give the statement with so much so accuracy. Therefore, the Court of Appeal held that it was in the interest of justice that the statement was admitted, and it was the correct thing to do. The court was not interested the procedure in which that was adopted to adduce the evidence. Next that I would consider is the case of Clark. The case of Clark is here a very violent burglary took place. The victim said that he doesn't recognize the attacker. Privately, he admitted to the police that he was in fear of the attackers. There was a lady who was in the house when the defendants broke into the house, and she identified. The police officers gave evidence of what the victim had told him, but he denied that in evidence, that the defendant was the attacker. The victim expressed his concerns as to what that violent man might do, and there was evidence of him being in fear. At court, in trial, the witness did give evidence, but he was too frightened to say who the attacker was. However, the Crown did not seek to establish that he is adverse to their case, therefore he should be treated as hostile. There the Crown adduced evidence through the officers what he had told them off the record. And the police officers did give evidence to that effect. His case was that the police are lying. Therefore, there was other evidence where it was compelling to say that it was the defendant's blood inside the victim's house. Judge considered section 114 and 16 and allowed the evidence in on the basis of interest of justice. It appears that it was admitted under section 116, and the judge did not give the usual direction on hearsay evidence to the jury. Defendant was convicted and he appealed. The Court of Appeal basically said that the issue of section 116 need not be necessarily considered, as the evidence was overwhelming against the defendant. In paragraph 42 of the judgment, the Court of Appeal said this: accordingly accepting, as we do, that this case was properly put before us because it has raised some interesting questions, we do not need to reach any final conclusion on whether or not the evidence was properly admitted under section 116. We are prepared for the purposes of this appeal to proceed on the basis Mr. Akel's submissions as to section 116 were correct, but we reject the assertion the conviction is unsafe. The evidence of PC Pow apart was overwhelming. There you say that so long as the evidence is there, the courts not necessarily will interfere with the decision taken by the judge. Next, I pose to us the question, where is the requirement for leave to be granted comes from? When you look at Section 116 subsection 4, you will understand. Leave may be given under section 116 subsection 2e only if the court considers that the statement ought to be admitted in the interest of justice, having regard A to the statement's content, B to any risk that its admission or exclusion will result in unfairness to any party to the proceedings, and in particular to how difficult it will be to challenge the statement if the relevant person does not give evidence, does not give oral evidence. C. In appropriate cases, to the fact that a direction under section 19 of the Justice and Criminal Evidence Act 1999, special measures for giving of evidence by fearful witnesses, etc., could be made in relation to the relevant person and to any other relevant circumstances. You may wonder why in this particular gateway that leave is required. The leave is required for the simple reason is this. The witness is available to give evidence. If there is a fear, then there are other options that are available to alleviate the problem, such as special measures, witness protection, screens, live links, and the like. Otherwise, it's very easy for any witness to make the statement accusing the defendant and then to say, I'm in fear, don't have to give evidence. To overcome that hurdle, to overcome that kind of an abuse, possible abuse, this particular provision has been put in place. We are now going to look at the next, what is the procedure for establishing fear? The case of Neil and North Antrim Magistrates Court illustrates the point. There were two boys who saw an incident, gave evidence, statements to the police, and they were contacted to give evidence. Their mother told the police, sorry, they are in fear, they don't want to give evidence and they will not be giving evidence. Then their evidence was admitted. The matter was appealed to eventually to the House of Lords because it was argued that there was physical and psychological worries. But what the Court of Appeal said, that may all very well be correct. But the police did not speak to the boys. Whom they spoke to was their mother. So what they have put before the court in itself is hearsay evidence. Had the police officer spoken to the boys and got statements from them to say that they are in fear, the problem would not have arisen. Therefore, the conviction was quashed. Then we could look at the case of Matty. Here, in essence, the Court of Appeal, if I recall correctly, said that it should be proved beyond reasonable doubt by the Crown if they wish to adduce evidence on the basis of fear. We have looked at the cases of riot and Horncastle, those cases earlier, so I'm not going to dwell on them. But what I will look at is a case which I think is very important. That is, actually, I might look at the case of Ravi. Ravi is a case what one should do if there's an allegation that where two defendants are in the dock and one is alleged to have put fear on the witness. Then it may be that the party who is not involved in putting the fear would first of all like to do is to distance himself from the co-defendant, instigate a detailed inquiry. 3, ensure that there is no link between the two co-defendants on this matter. And equally, look for a severance. Ask the judge to sever the case. Rely on Article 63D. The innocent defendant on this particular issue cannot have a fair trial because he will be tainted by what has happened with the co-defendant. Then look for the safeguards. In that manner, you can avoid being contaminated, being painted with the same brush of interfering with witness. Can the judge tell the jury why the witness is not at court to give evidence? In some instances, it may be, but generally no. If you were to look at the Crown Court Compendium here, it says this: in some cases it is possible for the jury to know the reason for admitting the evidence, e.g. where the witness has died, or the reason why a witness could not be expected to remember information recorded, and the like. But where the fear is, the judges will not say. Sorry, that is through fear. Because that could be to really damage the case for the defendant. What is the situation where the witness is giving evidence but not willing to tell the truth? There you can make a declaration to have the witness as a hostile witness. Of course, you go through the steps of declaring a witness to be hostile. In fact, this is the last case that I will look at before winding this part of the program. It is a case that is worth mentioning, which is Saunders. Here you would see a very good interplay between various parts of the legislation, that is section 114, 116, and it is quite interesting to see that. Here what happened was that the defendant was tried. The prosecution did not call witnesses because they believed if the witnesses were to give evidence that they will not be truthful. And the court allowed the evidence to be admitted under section 114 because of the fear that they had. And when he was convicted, he appealed to the Court of Appeal. There the Court of Appeal allowed that evidence to be admitted and said the judge was correct to have admitted in the first place. Because of the particular unique circumstances. If I recall the facts correctly, there was an argument and there was a stabbing. Just as the stabbing took place, the victim spoke to his wife on the witness's phone, and then a few minutes later a call was made to the police and she came to collect the phone. It was a very momentary period of time that she was away from the scene. She said that she didn't see who it was, but the family said that the witness had made a statement to them that she did see who it was, but she denied. She came to give evidence and did give evidence, but except for committing herself as to who the perpetrator was. So it is not a question that she did not give evidence. She did not continue to give evidence. The court somehow applied section 114(1)(d), the safety valve, and allowed that evidence. And the Court of Appeal upheld that. And the case was dismissed. So in concluding, you would note that the concept of fear as a gateway is not as easy as what people think. There is fear, therefore. No. You can keep on challenging, and you should be challenging if your opponent is going to adduce that evidence under section 116(2)(e). I hope that you have found this part of the program useful and interesting. Thank you for your valuable time. God bless.